afternoon, everybody. So, from Ljubljana, University of Ljubljana, Faculty of Law. So I'm professor of civil procedure, arbitration and international private law. I have worked previously as advisor to Constitutional Court of Slovenia, part-time. And I do have practical experience in arbitration. I have been a member of the ICC Court of Arbitration for 12 years. Currently, I'm chairman of the Ljubljana Arbitration Center, which is a very, in your perspective, it's a small arbitration center. I know you have a much bigger and more successful arbitration center here in Kazakhstan, actually, in Astana. I have prepared outlines of the slides of this course. And don't worry, this is 160 slides, 2 slides per page, so 80 pages. You will get it, I think, through the office in electronic form. And just for your interest, it's nothing is mandatory, but also we can skip some slides. Of course, we will not go through anything, everything. We don't have time for that. But if you have interest, you can have a look later. Or of course, there is also my email address. You can send me any question or remark or feedback. Please do. I should thank my host. So your university, it's an honor and a pleasure to be here. It's my first time in Kazakhstan. But I will stay a bit longer. My course here, my guest visit here is till Friday, but then I stay till Tuesday. So I will intend to visit first Petropavlovsk and then Almaty. Have you had arbitration law before? Do you know anything about the topic? No. So I'm sorry, probably many things will be repeated. Some things, of course, you already know. But hopefully you will get some new perspective, at least in certain parts of this topic. And please do interrupt me anytime with questions or comments. That's in my faculty. That's the habit, is that we can have kind of discussion. It's not just one-way traffic. Okay? Please also remind me if I forget about the break, which we should do at around 11, right? So if I forget it, sometimes I forget to just let me know. So these are the topics covered. These are the topics covered in the materials, but we will not, of course, go through all of it. But this would be kind of outline of the course of international arbitration. As I said, arbitration is a broad topic. Now we only have 2 days here. But if you're interested, you can easily find a whole LLM program just for international commercial arbitration. So this, which will take over a year. Just some example about the curriculum of LLM courses in arbitration in US or England or Slovenia or Germany or Belgium. So it's international commercial arbitration, and this is, I should say, for the start, a genuinely international field of law. Most international of all fields of law I can imagine. Why? First, we have international, transnational legal sources of arbitration. You'll hear about UNCITRAL model law on international commercial arbitration. So UNCITRAL, it's a United Nations agency for international trade law, and it's soft law. So it's not international treaty. So, model law is It's an offer, and the countries then are free to decide whether they will adopt it into their legislation or not. And I think it's about 80 countries in the world that have adopted UNCITRAL model law. Kazakhstan state law on arbitration is not entirely in line with UNCITRAL model law, but you have special regulation for arbitration in Astana International Financial Center, and that one, you can easily find it in English, is totally in line with UNCITRAL model law. Furthermore, then you have New York Convention on Recognition and Enforcement of Foreign Arbitral Awards, and this is genuine international treaty, probably the most successful international treaty in the world when it comes to number of parties, Kazakhstan included, I think like 150 states. Practically all states in the world are parties to the New York Convention. So if you ask yourself, how is, let's say, an arbitral award from Australia enforced in Kazakhstan, should be exactly the same as a Kazakhstani arbitral award is enforced in Slovenia or Australia, because this is universal. Furthermore, if you ever look at a monograph or a textbook or commentary on arbitration law, you will see transnational references to case law of different national courts. In Slovenia, academics, but also courts, they would cite, they would make references to case law of England or France or Switzerland. There are really no borders, so these mutual references are common. And then, of course, finally, perhaps this is what we should start with, it's the parties. Arbitration, commercial arbitration, is most often used for resolving big international trade disputes. In private law, so commercial disputes, but parties from different countries concerning projects which have certain cross-border element. So you will have parties from different countries, you will have arbitrators from different countries, and you will have lawyers from different countries, common law tradition, civil law tradition, and this is also this universal international mix and cross-references and influences. You will see many things from common law that influence arbitration, and then vice versa. Also, most influential arbitral institutions in the world are also genuinely international. You will have international arbitrators, staff of arbitral institutions. For example, ICC Court of Arbitration is in Paris, but it would be wrong to say this is French arbitral institution. It's truly international. This is probably one of the very few definitions. We will be more practical, but let's start with the definition about arbitration. What is arbitration? So it's a neutral private body. So it looks like a court of law, but it's not state court of law. Arbitration is private body. Why does it decide disputes? It decides disputes because parties agreed by contract, arbitration agreement, that they submit their dispute for resolution to such private body. So in this sense, arbitration is contractual. Parties agree. Arbitral tribunal as a private body has no jurisdiction in itself. It's not like state court of law. Only if the parties agree it will decide. But then there is also a public law element, jurisdictional element. Namely, once the arbitral tribunal or arbitrators decide, their decision, which is called arbitral award in English, has the power of the judgment of a state court of law. Res judicata, finality, that's it, that's over, and it's enforceable. enforceable in the same manner as the state judgment. So you have this contractual element, the agreement of the parties, private body, and then you have this public law element, the effect of arbitral award, enforceability, res judicata. For some concepts, I can only make reference also to your law in English. And more or less, this is all in line with generally universally adopted concepts. Perhaps also to distinguish, now arbitration is part of alternative dispute resolution. Say, out-of-court dispute resolution, private body. Of course, arbitration is not the only method of alternative dispute resolution. A big thing, I'm not sure, I'm not familiar, I apologize how it is in Kazakhstan, but big development is mediation. What's the difference between arbitration and mediation? Well, arbitrators, it's a private body, but they decide as the court of law. They decide in the same manner as court of law. Apply, so find facts, apply law, and decide, and this will be final and enforceable. Mediator, on the other hand, does not decide anything. Mediator only assists parties to reach an agreement. It uses certain techniques and skills, mediation techniques to get parties together, but then in the end it's up to the parties whether they will accept a settlement, consensual resolution, and that's it. If they don't, mediator has no power to decide. Now, arbitration is used instead of state courts. You have a right, in your constitution, you have a right of access to court. You can bring your dispute to the court of law and the court will decide. But now we have arbitration. You can use it if you want, if both parties agree. So I invite you to tell me, why would you choose arbitration? It's not mandatory, you can go to the court. Why would you choose arbitration instead of court of law?
Because they have only one decision.
One decision?
Yeah.
Okay, that's important. One decision, one instance. If you go to the court, you will have first instance, you will have appeal, and then probably you can also have another further appeal on points of law to the Supreme Court. 3 instances, whereas in arbitration it is practically always just one instance. Yes, then there is a possibility to file an action for setting aside the award. You can attack the award in court, but for very, very limited reasons. It's not the full appeal. It's very limited. So basically you're right, it's one instance. And if it's one instance, it also means that it will be quicker for this point already. It's not the only point, you know. The time is probably one of the most crucial advantages. I don't know how it is in Kazakhstan state courts of law, but in my country, there is a queue. You need to wait. Courts are overloaded. So your case will not get on the agenda next week or next month, but perhaps only after a year, and then it takes time. Whereas in arbitration, it will start immediately. Arbitrators are paid for that, and they will need to take care that they do their job quickly. So, time, one instance, anything else?
You can choose judge, maybe.
Right? You can choose arbitrators.
Yeah.
In state court of law, the judge will be assigned to the case by some automatic mechanism. But here, usually you would have a tribunal of 3 arbitrators, so each party chooses one, and then these 2 would choose the third one, who will be the presiding arbitrator. So You have influence who will decide your dispute. You can find a person you trust, and you can find a person who has special skills in the area of law. You know, I'm sure judges in state court of law, let's say commercial court, are all very good experts. But you know, it might be energy, oil and gas, it might be construction contract, it might be antitrust, it might be distribution contract, it might be time sharing. So you cannot expect everybody to be a real expert in everything. But here in arbitration, let's say if you have a big construction contract, you can choose an arbitrator who is really an expert in construction law. Anything else?
Maybe like 64. Deal's decision in arbitration court will be faster than in useful court.
Usually, I said
because we have only one station, not two, like in useful.
Usually, it's quicker. That's true, and you get enforcement quicker. Do you think it's also cheaper? Usually we say time and money. Quicker and cheaper. Would you think arbitration is cheaper than court proceedings? Well, traditionally this has been said as an advantage of arbitration, that it's quicker and cheaper. It's not cheaper. When it comes to these big arbitral institutions, this costs a lot of money. You know, you have to pay extra. You have to pay a fee for the institution, and then, of course, and this is the biggest expense, you have to pay fees for the arbitrators. Arbitrators work on a contractual basis. They work for the business. You have to pay them. You cannot pay the state judge. They get their salary. So arbitration, we would say, it has a lot of advantages, but it's a kind of luxury. You pay more, you get more. Although, then in the end, I said it's expensive, but I get back to what you said, and what you said, it's only one instance, so you will pay more, but only for one instance. There won't be further payments for appeal and for Supreme Court, and then the court quashes the judgment and it goes back again. So, you know, sometimes we say time is money, so it's an expense. It is an expense, but it's worth paying for it. Anything else? Let's see the list. First, for international disputes, you get a neutral forum or appearance of neutrality. Let's speak frankly. If you have a dispute between a Kazakhstani company and Slovenian company, Kazakhstani company will not be happy if the dispute is decided by the court of law in Slovenia. They will feel that they are in kind of disadvantage. And the other way around as well. Perhaps this is bias, but this is fear in economic business community. You don't want to go to have a dispute resolved in a court in a country of your opponent. If you choose arbitration, you can choose a neutral forum, and even if it's, let's say, arbitration in Slovenia, the arbitrators will not necessarily be Slovenian. It might be one Kazakh, one Slovenian, and one, I don't know, American as presiding arbitrator. So you have this neutrality, or perception of neutrality, which in international trade is extremely important. Time, we said that. Flexibility of procedure. Court proceedings are determined by law, You have civil procedure code, like 500 articles, everything is pretty much firm. Arbitration laws would typically have 40 articles, and then you have rules of arbitral institution for the 40 articles. So you can see immediately much less is regulated, so much more is left to parties' decision, to arbitrator's decision, so it's more flexible. Parties decide on the matter of procedure. Can choose seat, number of arbitrators, well, usually it will be 1 or 3. Language. Well, if you go to state court of law in Slovenia, the language will be Slovenian. You will need to translate everything. In arbitration, it's a private body, just like we here we speak English, so you can choose arbitration and the language of proceedings to be Russian or English, regardless of where arbitration is based. Confidentiality, also important for business community. You can keep your dispute secret. You won't have it reported in newspapers every day. It's not good for business if it leaks out that there are some big disputes with your company. In state court of law, there is principle of publicity. Public trials are public. Arbitration, on the other hand, typically is confidential. There will be no public, and also the parties and their lawyers and the staff of arbitral institution will need to keep things confidential. We said arbitrators are usually more specialized than judges in the type of dispute. You can choose an expert. Then, also important for international disputes, you know, if your opponent is from Canada and you have decision here in Kazakhstan, it doesn't help you if your opponent has no money here in Kazakhstan. You will need to enforce the award in Canada because that's where the assets, the property of the defendant is. And arbitral awards, because we have this New York Convention, are typically easier to be enforced abroad. It's much more difficult to enforce, let's say, Kazakh state court judgment in Canada than Kazakh arbitral awards in Canada. And this is important, you know, in the end you don't want a judgment, in the end you want money, you need to get it enforced. No restrictions in choice of a legal counsel. Now, I'm quite sure if you go to a state court of law here in Kazakhstan, you will need, if you choose to have a lawyer, it will need to be a lawyer from Kazakhstan. In arbitration, because it's a private mechanism, there are no restrictions. You might have arbitrations based here in Kazakhstan. You can choose a lawyer from Slovenia or from Russia or from USA. No restriction. It's a private mechanism. Language, we said that. Service of documents, also important. So if you have court proceedings here in Kazakhstan, but the defendant is from Slovenia, you will need to serve a claim on the defendant. And if Kazakhstan is not a party of the Hague Convention of Service of Documents, it will be a difficult task. You will need to go through embassies, diplomatic channels. It takes time, it requires translations, it's not reliable. Arbitration, private mechanism, no problem to send a claim on the address which was stipulated in arbitration agreement if this is the last known address. So much easier to serve documents. So you see a big list of advantages. So it can be a sensible commercial decision to get already in the contract arbitration clause, so the dispute will be decided in arbitration. Time. This is just one proof. This is Stockholm Arbitration Center, very influential, important arbitration center. And you see majority, it took between 6 and 12 months to get an enforceable award. It's only one instance. Confidentiality. Now, you study not just law but also economics. It's an interesting topic. We said, if there is a leak of information that your company is sued somewhere, perhaps you will win in the end. But already the fact, if it becomes public, that you are a party to some major dispute, may negatively affect stock prices. And in arbitration, as we said, you can keep it secret. Cheaper. I invite you to check websites of some arbitral institution. There you have so-called cost calculator. You type a value of claim, you type a number of arbitrators, and it will give you a rough calculation of costs. Here, one example. ICC award, $10 million. $10 million is not considered to be a very big dispute in international commercial arbitration for ICC cases. This would be somehow average. So $10 million. In the end, the costs of arbitration would be $400,000. So this is, of course, more expensive than the state court. But $400,000, it's only for arbitrators and the arbitration fee. This does not include the costs, which will be, in every case, the biggest costs. What are the biggest costs in every case? For lawyers, legal costs. You will have to pay your lawyer, and if you lose in the end, perhaps you will need to reimburse the expenses of your opponent. This was one survey made, and the practitioners were asked why they choose arbitration, and they see, interestingly, still they think that they see that, of course, it is more expensive, but it pays off. It is still money well spent. So costs, time, enforceability, neutral forum, specialization of decision makers. It offers business solutions. These would be the major advantages. As you will hear, arbitration there are two types. Ad hoc arbitration, we'll discuss it later, and institutional arbitration. You have in the world famous, influential, reputable arbitral institutions. So if you include an arbitration agreement in your contract, you will also need to choose which arbitration. And you have a lot of influential players in the world. Asia, probably the most famous, Singapore International Arbitration Center, ICC, International Chamber of Commerce, in Paris. They also run the Court of Arbitration. This is probably the most influential institution in the world. London Court of International Arbitration, also one of the leading. Stockholm Chamber of Commerce. This is in Sweden, so this is also a very important arbitral institution already from the times of Cold War. So that was typically if a company from Soviet Union and a company from Germany, West Germany, they had a contract, they would have arbitration clause, they would choose Sweden because it had perception of some neutral forum. And that was the reputation in the time of Cold War. so East-West Europe. But the reputation was retained. Now, even now, just recently ago, important Russian companies, for big disputes, they often included the arbitration clause for the Stockholm Arbitration Institute. So, very big disputes. Austria, Vienna, that's important for Slovenia. Singapore and Hong Kong, these would be two most influential in Asia. See, I use this opportunity to say that arbitration, we choose arbitration because we want to avoid state courts. This is waiver of right of access to court. And then some people would think, so it's good for arbitration if the judicial justice system, the state courts in certain countries are bad. Because if the courts are bad, then you choose arbitration. It doesn't really work like that. If you see these most important arbitral institutions, they are all in the countries where also the regular state courts of law enjoy high reputation. Probably in Asia, Singapore and Hong Kong are two examples for the best functioning regular justice systems, state courts, but also then for arbitration. You know, you still will have some connections with state legal order, lawyers from there, you will have certain, although limited, control by state courts. So it goes hand in hand. You have good justice systems, state courts on one hand, you have good ground for developing arbitration. This is AAA from USA, Germany, and of course China is economically important, so also the Chinese International Economic and Trade Arbitration Commission, CETAC, is of course rapidly growing in importance. One of the newer institutions, Dubai International Arbitration Center, I mentioned it here because this served as a model for something that you have here in Kazakhstan. I mentioned ICC arbitration. That was, I said, $10 million is a rather low dispute. You see, $30 million would be a typical average value claim in this ICC arbitration. And this gives you an impression, or let's say proof, that this is really international. It's based in Paris, but you see seats of arbitration are, it's not necessarily Paris. Paris is only a minority. You are not limited where the seat will be. You choose law which will govern arbitration. And you see from the parties, they are also from all parts of the world. I mentioned this is, by numbers, very impressive arbitral institution which you have in Astana International Financial Center. There is a court and there is this International Arbitration Center. Totally independent, and I would say although the law, it's called arbitration regulation, is perfectly in line with, say, worldwide trends or expectations, and also the IAC arbitration rules are a high quality and modern set of arbitration rules, so well suited for international arbitration practice. I said in arbitration you will have lawyers and parties from abroad, from all parts of the world. So it's important, it's very important that when lawyers come to certain, a European lawyer comes here, that he will not be surprised by some strange arbitration rules and arbitration laws. So it's a good choice to have it more or less the same everywhere, because then you know what you can expect. So this, I would say, is it's quite impressive project, and it's based, this was the first similar one, was Dubai International Financial Center Arbitration, and this is a similar project. So this is my arbitration institution. It's very small comparing to what you have, but that's where we are. The numbers perhaps might not seem so big, but if you take into account these are very high value disputes, this is important in the world economy. One thing with institutional arbitration, you see this below, this is Dubai International Arbitration Center, this on the top, this is Singapore International Arbitration Center. It looks like a court. And these are rules of such institutions. And the rules, they look like law. So one would make a comparison with this. This is also a court, this is your Supreme Court, and this is your civil procedure law. People would tend to think this is similar. That's a law, this is law, that's a court, and this is court. No, it's different. This is court. But this is not a court, this is a private body. And we said institutional arbitration does not in itself resolve disputes. They only offer service. They say they administer disputes. Assist, control, administer. Courts of law don't administer disputes, they decide. But arbitral institutions, they are just service. But then who decides? The arbitrators. Either one or sole arbitrators, sole arbitrator, or arbitral tribunal. Ad hoc arbitration, we have institutional arbitration and ad hoc arbitration. What is ad hoc? Ad hoc is arbitral institution which is arbitration which will be established only for this dispute. Let's say 1, 2, 3 colleagues there, and we have a dispute with a colleague here. We could say, well, our dispute will be decided by arbitration, ad hoc arbitration, and this will be these 3 colleagues over there who will decide, and they will be ad hoc arbitration. It's no institution, they will be paid by us, but what they decide, the arbitral award that they will render will have force of a court judgment. That is ad hoc arbitration. We will have a hearing. Where will we have a hearing? Well, we can rent a room in a hotel, and that's it. There's no institution there, no service behind. So that's ad hoc arbitration. So which should we choose, permanent or ad hoc? What is better? You 3 would probably say you 3 are better. Probably there are still more advantages for permanent. There are certain secretariat, there is reputation, there are techniques, there is certain practice, there are certain rules, and they will also control the costs. You know, that's important. We didn't say anything about costs of arbitrators. It's not only the fee. Let's say we will have a hearing, and the hearing will be in London, and the arbitrators will travel to London. But then it's important, it's practicality. Will they travel first class or economy class? You know, it can be for 3 arbitrators, 3 hearings. It can quickly be a difference of 20,000 or more euro. What kind of the hotel can they book there? Because we will pay for that, the parties. If you have ad hoc arbitration, there are no rules. You have to be very careful. If it is institutional arbitration, the institutions will usually have guidelines for costs and expenses. Is there any advantage for ad hoc? it looks even more private, there is no institution behind, more guarantee of confidentiality. You know, when we said confidentiality, one thing is to say you have to keep it secret, the other thing is when you really keep it secret. In my country, when we have some discussions in parliament, they're in secret. Next day, it will be all in newspapers because somebody will leak information. More people will hear it, more possibility is that somebody will sell some information and it will not be secret anymore. And in institutions, you have secretariat, you have files, you have people who will see it. Ad hoc, it will be only 3 of them. So there is bigger chance that there will be no leak of institution, of information. And of course, in institutional arbitration, you also need to pay for the institution and you need to pay for the arbitrators. Ad hoc, there is no institution, you only need to pay for the arbitrators. Last, before the break, some general concepts. I said we need to distinguish between institutional and ad hoc arbitration. We also need to distinguish between domestic and international. Domestic would be a dispute between 2 Kazakh companies. International would be a dispute between a Kazakh and a Chinese company. So it depends on the parties. Although, you know, this distinction is not so firm, because you can also have a Kazakh company but it's 100% foreign owned. In law, this would still be 2 Kazakh companies, but if you know it is 100% foreign owned in economic and commercial sense, this is cross-border. I'm not sure whether you have different rules for domestic and international arbitration disputes. For example, in my country, we don't distinguish this. Second, domestic foreign. It's not the same. Domestic international, it's about the parties. Domestic foreign, it's about the nationality of arbitration. And the nationality of arbitration depends on the seat, typically depends on the seat of arbitration, the place of arbitration. The place of arbitration is not necessarily the same as the place of arbitral institution. You saw ICC Court of Arbitration has sit in Paris, but parties are free to decide the legal, juridical seat anywhere. But this is what will then determine whether we have domestic or foreign arbitral award. If arbitration has sit in Kazakhstan, this will be domestic arbitral award. If arbitration has a sit in Slovenia, this for you will be foreign arbitral award. And this is a very important distinction because, you know, Kazakh courts of law will only have certain jurisdiction concerning domestic awards. Assistance, control, setting aside. But on the other hand, Slovenian arbitral award, if you want to enforce it here in Kazakhstan, it will need to go through the procedure of recognition and enforcement of foreign awards. And we said New York Convention. And then we have arbitration in special areas. Consumer dispute, this is a very interesting topic. Is it advisable to have arbitration as a mechanism for resolving consumer disputes? Typical inequality of the parties, small claims. Not this type of arbitration. Perhaps some special rules, special arbitration, but in general, we need to be careful. About sport, probably even if you don't study law, you watch Olympics, you see, you heard about arbitration of sport. It's in Lausanne, in Switzerland. CAS, Court of Arbitration for Sport. cases, results of Olympics, commercial dispute about transfers of players and fees that need to be paid. This was a Slovenian one, doping, so forbidden substances which sports and sometimes use. Pechstein judgment, this was also about doping. You know, the problem with this arbitration for sport is that it's voluntary, you sign the agreement, but in practice it's not really voluntary, because perhaps you don't know that if you qualify for the Olympics, before you go there, like this Winter Olympics, before you go to Beijing, Peking, you need to sign an arbitration agreement. If there is a dispute, it will be resolved by CAS, by this arbitration for sport. You are free not to sign, but if you don't sign, you will not go to Olympics. So that there is this question, is this really voluntary? And there was an important decision in this Pechstein case by the European Court of Human Rights. It's somewhere on the borderline. Perhaps you're more familiar with that. The expulsion of Russian athletes. And recently in Beijing, this Valieva, the Russian ice skater case, which was decided by the Court of Arbitration in favor of this Russian skater. And one of the applicants here, the second one, was one of the applicants, but the arbitrator, Vesna Bergantra Kočić, Slovenia, so she's a judge, my friend, in Slovenia. So, you're familiar with the case, you've heard it. ICSID, and this will be the last before the break. International Center for Settlement of Investment Disputes, Washington arbitration. Investment, so state on one hand and the foreign investor on the other hand. So if the foreign investor believes that his rights as an investor have been breached, he can bring the claim against the host state. It will always be a state, one party, to this international arbitration mechanism in Washington, the Washington Convention. And these are usually huge disputes. Slovenia had a couple, Kazakhstan had a couple. Really the last one. Can we have compulsory arbitration? No. Arbitration can never be mandatory. I mean, in the other words, if it is mandatory, then it's not a real arbitration. For arbitration, as a starting point, this is consensual, this is contractual. Parties agree that they will go to arbitration. If they are forced by law to go to arbitration, that's not arbitration. Arbitration can only be voluntary. Now, you have, again in the old times, Soviet Union, you had Arbitration Sud, which had mandatory jurisdiction for cross-border disputes. And the name of arbitration, and that was not a real arbitration because it was mandatory. The name Arbitration Sud was retained, but it was just a Russian commercial court. But I think recently they changed the name of Arbitration Sud. But that's a relic from the old times when you had this kind of arbitration that was not a real arbitration. And so it's a state court. Any question before we make a break?
No question.
No question. Is it okay to go in the same style after the break? So, the break will be, you decide. What's the usual time?